to that person. So nobody can use, manufacture, sell the patented or the protected work without the consent of the applicant. So if anyone doing so by intentionally or unintentionally, then what an individual can do? The individual can file a case against that person and can claim the damage. The damage can be claimed by the person who has granted the intellectual property right against the person who is not, who is using, manufacturing your product or the patented article, patented process, protected process without your consent. So, to acknowledge the hard work of the individual, these intellectual property rights are needed. It provides protection to the intellectual labor of the person. So, as we know, these are the creation of the mind. So there are two type of labor we can use. We can put our physical work. We can put our mind work. So these all work are called intellectual labor, or intellectual rights, intellectual work. So to recognize the effort of research and development. So if someone is working in the research and development field, like your institute is working in R&D field. So if you apply for a patents or the intellectual property rights, and you have number of application, you have number of rights granted by the government, your development, research and development work will be recognized by all over the territory. So you can, the research and development work can be recognized, because someone, whenever we are just doing our research, it is very precise in a particular field. So that research can be recognized by using a intellectual property rights. And whenever we are applying IPR application, so you are the owner of the IPR applications, you are the owner of the intellectual property related to your research. So if these invention, if these work is already granted to you, then nobody can also beat you in terms of your research, because you already granted the rights. So that right cannot be granted to anyone else once the right is granted, the rights are granted to you over the work. So on the same work, nobody can get the right again. So that's why this is an exclusive right. Nobody can get the right again over the same work. So that's why it promotes the research and development work. It is a tool to develop the innovative practice. So that innovative practice is increasing by the protection of the intellectual property rights. It increases the revenue. Once we will take example of revenue, how the revenue can be generated, and how much revenue can be generated. By the ending of this slide, we will tell you like how the revenue and how much the revenue a person can generate over a single intellectual property right, not a bunch. Bunch is a different thing, and over a single intellectual property right, and a single patent application or a single IPR application, you can earn a lot. So without the production of creativity, innovation, business and individual would not reap the full benefit of their invention and intellectual property creation. If you don't protect the right, if the government don't protect the right of the researcher, then they cannot reap the advantage of the full of your invention. Like in India, it is happening. Whenever we are opening any hotel or anything, like today there is a applicant come to me and he has just given me a trademark application. So like he has running his business on the name of Kullar King as a restaurant. He is running a business. So whenever I check this Kullar King So it is already taken by someone else. But I don't know the person who has already taken the Cooler King just 3 months ago when he has started the business. But the person who has came to us for trademark, he is working in this field on the same name from previous 5 years. But he has not protected, he has not applied for any IPR rights. So that's why now he cannot open the franchisee, and the name can be given to anyone else, and anyone can open the restaurant on the same name. So that's why to prevent the competitor in the market, we need to apply intellectual property application, so that the competition, the person cannot copy your name, brand, your invention, anything related to your belongs to you, that they cannot copy. That's why the IPR rights are very important for in any field, not in educational, not in startup, not in the case of companies. In every field where we are putting our effort to develop something, that effort should be protected. So we need to take the initiative to protect our effort first. Then the government will take the initiative to protect your effort. If we do not file intellectual property application, then the government nothing they can do. So what type of intellectual property rights are exist? So first of all, very important right is patent. This is very widely used. We have all listened about the patent. So this is one kind of intellectual property right. So what can we cover? We will discuss later what can we cover into the patents and copyright. So I'm just taken one example. So copyright is another type of intellectual property right. So what we can cover in the copyright is book, paper, research paper, any authorship, any article, we can file a copyright request for that. Trademark, industrial design, sorry. The third one is industrial design. So what is the meaning of industrial design? That means the design of any product, the design of this Coca-Cola bottle can be protected under the industrial design application. So third one is industrial design application, industrial design patent we can also say. The fourth one is trademark. So every company having a particular trademark, like Microsoft, this is the sign of Mercedes, Coca-Cola, Intel, Sony, MTV. So every brand name having a own trademark. If we do not file a trademark application before making it brand, so generally what the people do, they just make the brand first and then apply for the trademark. But in this duration, other can take your name and you cannot do nothing. So the person who is just going to open the business, they need to first file a trademark application, so that if the business grow and it become brand, it should have a particular name, and the name or the brand should be registered on your name particularly. So do not waste the time by just waiting that we will apply later. So the fifth one is geographical indication. So geographical indication, let's say Assam having geographical indication of tea. So a geographical indication, that means any particular area can be indicated or can be known over a particular product. So tea, you can see. Who can file the geographical indication? So any government organization or any organization which is non-private, that they can file geographical indication. So this is not applicable for us layout designing. This is also one kind of intellectual property right. Plant varieties. So whenever we are making a fusion of two plants, we can file an application for a plant patent also. So we will understand what is the how we will categorize what is the invention, what is design, which application we should file. So we will explain everything in this, like what is patent. So what is covered under the patent? So patent, whatever the invention that means new thing. So new thing, new method, new product, new process, new technique, these all are covered under the patent. So like chemical fertilizer, process of manipulating genetic bit in mice, robot, anything related to invention, that we can file a patent application over that invention. So the protection of your right, your work under the patent is provided for 20 years in India. So every country having a different term, different type of patent also available in different country. So this is we are explaining